Hello, Kip from Malek. Today I'm going to be discussing the question of can you volunteer and receive temporary total disability compensation? Or can you do any type of kind of work activity, whether or not you get money yourself and receive temporary total disability compensation? So the general rule in Ohio is if you are receiving temporary total disability compensation, you can't do work for anyone, whether that's the employer where you got injured at or Uber, DoorDash, Lyft, one of those gig type jobs. And sometimes that comes up because folks aren't aware that you can't do any type of work and you can't get any type of money. And so that's the general rule. That's a hard rule. You can't violate that rule. And if you are receiving temporary total disability and you knowingly work and make money, then again, I've done other videos about this. You may be found to have committed fraud. There may be an overpayment. So just beware. But this is kind of a little bit more tricky question. Again, if you're working but you're not making money, or you're doing a work type of activity and you're not making money. So generally in Ohio, there's three things that the courts will look at to determine whether or not the activity you're performing conflicts with your receipt of temporary total disability compensation. And the first rule is, are the activities you perform, are they medically inconsistent with the physical capabilities listed in your Medco 14s and medical records? So if you're sitting there telling your doctors, hey, my back is really injured, I can barely lift 5 pounds, and it's documented in the medical like that, and the Medco 14s have work restrictions or you're off completely, and it's noted that you can barely lift more than 5 pounds, and then you're found to be in your garage changing out an engine block or doing something else which would be inconsistent with that documented disability, that would be bad. So in that case, you would not be entitled to temporary total disability compensation. Second rule, whether or not you're receiving income yourself, are the activities you're performing directly generating income? So are you working for, like, and I'll talk about specific examples, but through the cases, but are you working a cash register and that transaction is generating money for a business? It doesn't matter if you get money or you're paid for that business. Are the activities that you're doing generating money for that business? So that's the second rule. And then the third thing that they're going to look at is, are the activities you're performing, can they be qualified as minimal in nature? So and that's kind of a squishy factor, but they're going to look at that, and if they determine, oh, that's more than minimal, you're really kind of doing a lot of these things, then they might construe that as work, whether or not you're getting income. So as with everything workers' comp related, it's best to look at how Ohio courts have addressed this issue. So there's three cases, primary cases, Supreme Court cases I'm going to talk about. The first case, Parma versus Jankowski. The second one is Ford Motor Company, and the third one is Honda of America. So Parma versus Jankowski. So this nurse was working in this Parma Community Hospital. It looks like she injured her arm, and while she's healing from her arm injury, it kind of seemed like the medical was indicating, kind of hinting, hey, this arm injury is going to kind of kick her out of doing this type of work for the foreseeable future, if not for her life. And while she was receiving temporary total, she volunteered at a child support agency, and it happened to be where her brother worked, and so she volunteered there, and the court analyzed this, and then apparently either the BWC or the employer did an investigation, and they were concerned that she was working, and their issue was, well, she shouldn't get temporary total disability. So the Supreme Court looked at this, and again, they determined it was unlikely she'd be able to return to her job as a nurse, and she wanted to become possibly paralegal or something, and so this working at this child support agency in a volunteer capacity was kind of, it was basically like learning experience. She didn't get paid, and so the court said, they don't want to discourage people from participating in unpaid internships and apprenticeship programs. So that was one thing they came up with. The other thing and this would go to that first rule I talked about. The activities she was performing at the child support agency were not inconsistent with her physical capabilities and limitations listed in her medical 14s and medical records. So her injury, her issues were with her arm. Presumably she can answer the phone with the other arm. She's sitting on a chair, presumably. Doesn't have to lift up patients and be physical like she would in her nurse job. So they didn't have a problem with that. And she didn't get paid for her activities, and her activities didn't generate income for the child support agency. And then the final thing that they made, the distinction that they made in this was just because performing an activity in the normal course of things could result in payment does automatically preclude someone from receiving temporary total disability. And it's hard to understand what that means unless you look at an example that they kind of enumerate. And it's kind of, if you're babysitting your grandkids, for instance, generally you could babysit and make money. That's kind of what they're saying, but they're just saying as long as you're not getting money from that and everything else is copacetic, you can do that. Likewise, if you could mow your grass, as long as that's not inconsistent with your work restrictions and you're not getting money, you could mow your grass. Now, can you mow grass for other people and make money? Yeah, but the court is saying just because an activity that you do could generate money doesn't necessarily preclude you from doing that activity, assuming the three things are still copacetic. So that's one of the big cases, the House Supreme Court case. The next case is this Ford versus Motor Company, or Ford Motor Company, and in that instance, the injured worker, he had, besides working at a Ford Motor Company, he also had a lawn care business, and so once he was temporarily totally disabled from his Ford Motor Company job, and he was still running this lawn care business, and the Supreme Court determined that that was okay. And the reason why they said it was okay, and they said he's not required to close down his business just because he's receiving temporary total comp. And the reason why is the following. His activities were qualified as minimal. The activities he was performing for the lawn care business were minimal. He didn't mow any lawns or perform any other physical activities as part of the lawn care business. And here's the thing with all these cases, there's always surveillance. So he was only surveilled gassing up the lawnmowers and putting them up on a trailer a few times. And then as far as his actual money part of it, he wasn't generating money directly, i.e. he wasn't going out to customers' lawns, mowing the lawns, and then getting paid for that. What he was doing is he was signing paychecks, and the paychecks obviously were for the employees that he had in his business. They're the ones who were generating income directly. So he was generating income secondarily through signing the paychecks, and the employees were the ones who were actually generating the income directly. And that was kind of a big distinction in this case. But the point is, in this case, it kind of stands for you could have an outside business as long as, again, you're copacetic with the three factors, that's okay. Now, if this guy, he had physical limitations, if he had psych limitations, and the psych limitations were, he gets anxiety and he's getting depression and all these things that would preclude somebody from necessarily managing a business, that might be inconsistent with his physical or psych limitations. So you have to look at every one of your factors on a case-by-case basis, your factual situation. But that's how the court determined this. So they said this guy didn't have to close down his lawn care business. He could continue running the business as long as what he was doing was fit within those three rules. So that's the Ford Motor Company. Another case, and I don't know why it's just kind of coincidental. Both these cases deal with car companies. But the next case, Honda of America. This lady, the claimant was receiving temporary total disability, and she had opened a scrapbooking business with the proceeds of her husband's life insurance policy. The court determined that her involvement in the scrapbooking business was okay. Her activities were observed to be minimal. So again, there was surveillance that was undertaken, and it was on 5 different dates over a 3-month period. She was seen to be answering a customer's questions. She pointed out display, and she may have been touching the cash register. Her activities did not generate income directly. She didn't sell any of the items in the shop, and again, she was seen, they didn't actually see her like ring up a sale. Maybe if they'd seen her ring up a sale or two or three, maybe then they could say, oh, she was generating income directly, but they didn't see her do that. They may have seen her employees do that. And then in the activities she was performing in that scrapbooking businesses were not inconsistent with her physical restrictions. She was seen to be carrying a light tote bag into the office, and then when she would come to the front of the shop, she was evincing pain behaviors, and she was kind of leaning on like a display or something. So in that instance, again, a person had a business. The Supreme Court said it was okay. What that person's involvement in the business was fine. Now, this final case, this is a 10th district case, Meade, but in this case, this was an instance where the court said this individual's involvement with this business was inconsistent with the receipt of temporary total. And I can't recall if they just found an overpayment or they found an overpayment and fraud. But what ended up happening in this situation was this individual was again receiving temporary total disability compensation, and then he was working at his wife's business, which happened to be a pizzeria. He alleges he wasn't paid for his activities at the pizzeria, but nevertheless, the court looked at the facts, and they determined one, his activities in this pizzeria were not minimal in nature. He delivered pizzas, he made pizzas, he took customers' orders, he might have run up orders, and then they also said his activities generated income directly for the pizza business. So by making the pizzas, by delivering the pizzas, by taking the custom orders, that generated money directly for the pizzeria. So he may not have gotten a red cent from his activities, but that's not what the court's looking at. They're looking at, do those activities generate business directly for some other entity? So this area, if anytime you're receiving temporary total disability compensation, you need to really, if you're going to do anything, whether it's working, whether it's volunteering, anything, that's one of those instances where it's a third rail. You need to reach out, you need to alert your workers' comp attorney that is what you're doing, because this is one of those things that can really be bad for you. So in general, volunteering, you can do volunteer type activities with a caveat. And this is, again, one of those third rail things. You 100% need to consult with a workers' comp attorney or your workers' comp attorney before you engage in this, because it could be really bad for you. So, as always, at the end of these videos, workers' comp in Ohio is complicated. Reach out to a workers' comp attorney with your factual situation. You've been listening to Kip and Malek. If you have questions, concerns, anything, leave them in the comments below. You could email me, you could call me, and I'll try to address your issues. Appreciate you listening to this video. Please stay safe. Don't get injured. Good luck. Thank you.